Hello, and welcome to this next session in our mini-series on practice across the pond, where we're looking at transatlantic regulation of professional services firms and specifically of legal services firms. We spoke last time about conflicts management and how that's managed in international professional services firms. One topic that we didn't get to speak about last time that I had hoped we'd managed to cover was thinking about how partner conduct is regulated in each of our jurisdictions and how those tensions between different jurisdictions are managed. I'm going to come to you first, please, Andrew. Could you give us a sense of how the UK regulator regulates and monitors and what it expects of partner conduct in the UK?
Yeah, so the SRA has had a real focus on sexual misconduct in particular in the last several years, both inside and outside of the workplace. And that has resulted in some cases around proximity to practice and the extent to which the regulator can interfere, as it were, with individuals' private lives and the rules in the European Convention of Human Rights that say that people are entitled to a private and a family life. So we've seen a number of prosecutions in the tribunal in relation to sexual misconduct allegations, the most serious of which have resulted in individuals being struck off the roll. And the SRA is now looking more at firms as well. So when these incidents take place, they're looking at whether the firm culture played a role in that misconduct. Was sufficient training provided to make clear what expectations were? Were there any warning signs about particular individuals which weren't picked up on, etc., etc. So new rules were introduced into the codes of conduct last April, providing that individuals and firms must treat colleagues fairly and with respect and not bully, harass or unfairly discriminate against them. Have a particular obligation on partners to challenge unfair and discriminatory behaviour when they see it. So that puts an obligation firstly on the firm to ensure that those rules are followed, but also specifically on individual partners to challenge behaviour. We could theoretically see a case in the future where 3 individuals or entities are brought before the tribunal: 1, the partner committing the misconduct; 2, the partner that failed to challenge it; and 3, the firm itself. So there is a real spotlight on misconduct in the profession at the moment, particularly those sort of sexual misconduct, bullying and harassment, and how this all sort of plays into workplace culture and workplace environments more generally.
Devika, would you say that the same level of regulation applies in the US?
Well, in the US, we have built into our rules of professional conduct language there's a laundry list of what constitutes misconduct in the rules, and some of those rules are different from the ABA model rules depending on which state you're in. So it's really important for lawyers to look at the rules specific to their jurisdiction. But generally, there's a prohibition on unlawful discrimination and harassment in the practice of law. This is a separate ethical violation, and the definition of harassment is very broad. In New York, we have a catch-all rule for professional misconduct, which is where much of this kind of workplace conduct can be pulled in to a disciplinary complaint and therefore investigation and prosecution by disciplinary authorities. And that is the rule that prohibits lawyers from engaging in any other conduct. This is the end of this laundry list, non-exclusive list of conduct. So it's a prohibition on engaging in any other conduct that adversely reflects on the lawyer's fitness as a lawyer. So fitness is really the terminology that is used to let this rule be as flexible enough to address these kinds of problems. Our rules are interesting in the sense that while they are written in the context of a lawyer's duties owed to clients and the court system and to adversaries and others, all the duties that are outlined in it, they do not necessarily, some of them that is, distinguish between professional conduct and personal behavior when it comes to imposing disciplinary sanctions. by the grievance committee or the bar associations, and difference in states. So conduct such as inappropriate behavior at a workplace event or at the workplace itself during normal business hours, or improper online behavior with colleagues, or improper behavior in a bar, or driving while intoxicated, which may have criminal implications as well. These, I'm just sort of giving you examples of types of conduct that may not necessarily be in the lawyer-client context, but that happens to be personal behavior that the rules are concerned about, and the disciplinary authorities want to look at closely to see if this is sanctionable conduct. In New York, we have laws that apply to lawyers as well, including sexual harassment prevention training that is mandatory. And law firms have to run these and ensure compliance for everyone, non-legal personnel and lawyers included. So, and in the context of the workplace, I think a lot of GCs, including myself, we have looked at these issues that are coming up more and more in the workplace environment, and are trying to have more awareness building, training, workshops, continuing legal education, and to address how to really tackle them.
So would you say that the kind of the regulatory burden sort of supports and drives the culture, or do you think it is limited to prevention of rule breaking, if you like? Is it a cultural piece in the US?
It's a little bit of all of those things. We have to keep reminding ourselves that we have this overarching duty where both the law firms and the management level lawyers have a duty to adequately supervise so that everyone is in compliance with the rules. Since the prohibition on unlawful discrimination and harassment in the practice of law is one of the rules, that is a rule over which management level and supervisory lawyers have jurisdiction to make sure that the environment is fair, is equitable, and it's not a hostile environment, and to investigate and take steps if that kind of conduct is encountered or is reported. So I think it's complex in that sense. They're kind of intertwined with the duties that we owe under the rules, and also under the laws that govern us outside of the rules.
Well, that's really interesting, because it strikes me, Andrew, that our regulator has been incredibly clear about the fact that it is intending to set the tone, that it is about preventing and addressing toxic workplace culture. Do you think that's fair?
Yes, I do, and I think probably most regulators would say that the SRA has gone furthest in terms of its focus on these types of issues. Certainly, the financial services regulator is seen to be a bit behind the SRA, and they're publishing some sexual misconduct guidance at the moment, and they're consulting on new rules around treatment of colleagues. But the SRA has sort of really led the way in this. And we've talked about sexual misconduct, bullying and harassment and those things, but they're also looking more holistically when mistakes are made or people act dishonestly to cover up mistakes. So has that arisen as a result of someone being overworked or not being properly supervised? So there's also a focus on that side of things as well. So yes, they're looking at the misconduct, but they're also looking at perhaps not misconduct per se, but behaviours or cultures that can create an environment in which someone gets behind, makes a mistake, doesn't feel they can speak up because they feel they'll be shouted at or disciplined, and then they do something to cover it up, which has obviously devastating consequences for them personally. Usually can have devastating consequences for clients. The SRA now is saying in those circumstances, if we feel that the firm's culture has created that, the firm will be in the firing line as well. So that's a bit of a difference, because a few years ago we were seeing individuals struck off the roll for dishonestly but nothing was being done in relation to the firms. And in fact, that was one of the drivers of this focus on firm culture, the criticism of the SRA for taking action often against the young junior members of the profession who had, in a blind panic, done something to cover up a mistake, but not addressing environments which led to that mistake or that cover up in the first place.
And I think in another area, as I understand it, where the SRA is very heavily focused in the moment in the UK, is on anti-money laundering. And I think that, and I'd be interested in your views in a moment, Devika, that again, this is an area where we could say that the UK in particular is subjected to really heavy regulation. Obviously, not the rules aren't coming from the SRA in that particular instance. But it would be really interesting, Andrew, to hear your perspectives on the UK side of that, and then to think, Devika, about how that contrasts with how that issue is dealt with in US firms, and how the two fit together, really.
Yeah, so again, there's a real focus for the SRA. A new regulatory objective was introduced into the Legal Services Board's objective to promote the prevention and detection of economic crime. And as I said in the last episode, they're the oversight regulator, so that then feeds down into what all of the individual regulators have to do. And they've been conducting a number of visits to law firms, either online or in person, to check their due diligence, effectively, their file opening procedures, their AML policies, their AML risk assessments. And we're seeing two sorts of cases, either prosecutions of quite large firms before the Solicitors Disciplinary Tribunal, and those have been in relation to alleged failures to conduct adequate due diligence in relation to high profile or high risk clients, such as politically exposed persons or clients in particular jurisdictions. And then alongside that, we're seeing lots of sort of lower, smaller level fines for firms for failing to have adequate AML policies and risk assessments in place. So you've got the higher stakes sort of prosecutions for the larger fines, larger firms where they're alleged to have got this wrong, alongside action being taken against a lot of smaller firms for not having proper policies and procedures in place. And this isn't really so much an issue that's relevant to whether any harm was caused, actually whether any money laundering did take place. In fact, in a number of cases, they've been clear that no actual money laundering was facilitated by the firm's failure to have proper procedures in place. But it's just that the fact that the firm didn't have those procedures in place, or they weren't being updated, or in some cases they just weren't, the procedures were there, they just weren't being applied, that has resulted in action being taken. So understanding that, I think, particularly in a UK-US context, is going to be very important because of this increased burden. If a case is, perhaps a US client is referred to the UK for an urgent instruction, I think that there needs to be an understanding that there are these stringent requirements that the UK needs to comply with before they can onboard a client. And I know some firms, again, going back to what we said in the last episode of this sort of highest common denominator, I think if you were looking at the highest standard to impose, you'd probably be looking at the UK, or in terms of what you would do from when you're onboarding a client at the start of the matter. So you wouldn't have to have that potential delay if you ever did need to get UK advice.
And is that fair, do you think, Devika, that firms, possibly in the US, for example, I'd be interested in your views, where perhaps there aren't exactly the same procedural requirements and AML standards in play, do you think that they go with the highest to start off with, or do you think that actually there's sort of a local appreciation with an acceptance that if other rules are relevant in the international structure, that's a bridge they'll cross when they get to it?
I think it's a reasoned approach and a balancing of all of the things that Andrew has just mentioned. And the legal profession and bar associations around the US have made very broad strides in trying to combat money laundering and other forms of illicit finance. The American Bar Association in particular has recently issued reports and resolutions and made significant rule changes, which apply largely to those particular rules dealing with withdrawal from certain client relationships, and in what way to do it. As you well know, U.S. firms are currently working and managing the Corporate Transparency Act and its requirements. And as you might know, the Enablers Act, which was a potential federal regulation that was on the horizon. It did not pass Congress. So going back to the American Bar Association's ethics rule changes, they now specifically require firms to inquire into and assess the facts and circumstances of each representation to determine if the law firm should accept it or continue an existing relationship with the client, where the client or a prospective client is seeking to use or persisting in using the lawyer's services to commit or further a crime or a fraud. So there's this very engaged due diligence requirement that has been built in, and jurisdictions around the country, some have adopted it, some are currently looking to adopt it either wholesale or with some variation. And I think the ABA comments here are really helpful guidance, because they say a few things, that this due diligence requirement, this need to inquire and to assess, this obligation should continue throughout the course of the representation. So if there's a change in facts and circumstances, that triggers the need to make further inquiry and assessment. You know, it's not just one and done at the beginning, at the onboarding phase, as you know, Andrew was pointing out. You know, these are onboarding requirements, but and as he rightly pointed out, this is just how it has to be going forward. And an example that the ABA gives is I think extremely practical and helpful, because it's all about how should lawyers and non-lawyers on their team be spotting AML issues. So the example is a client who traditionally uses the firm to acquire, let's say, local real estate through a domestic limited liability company with a local bank doing the financing. Now, client comes back and it's the same client who then asks the law firm to create a multi-tier corporation, a structure that is formed in another jurisdiction to acquire property in yet a third jurisdiction, and using trust funds and doing a transaction through the lawyer's trust account. So it points out certain factors that lawyers should look at to assess the risk, and they include things like the identity of the client or the beneficial owners of the entity, the experience and familiarity with the client, the nature of the legal services, the relevant jurisdictions for the representation, and the identity of those who are both depositing and receiving funds from the trust account. And then the comments, which are very lengthy, do provide, and this is very, very helpful, further guidance for lawyers and law firms for their review and understanding of anti-money laundering and terrorist financing risks. And that they list a number of different documents which are very comprehensive and robust. And really the takeaways here for us in the US is, again, are firms looking to adopt the ABA amendments? And so it's really up to them, because the rules, as we've discussed in our prior podcast, the ABA rules are not binding on state bars or on the practice of law generally. They're only persuasive and they serve as guidance. So it's up to the states to really take more steps. And the other thing that's really important that people have been considering is that all our firms, big or small, and whatever their outreach, they need much more education and awareness about money laundering and terrorist financing. You know, there are red flags and risks that we all need to become much more familiar with and catch right away. While we may be much more conversant from a conceptual level about terrorist financing and money laundering, we may not have looked at those issues from a different lens, and that is the lens of risk management, and risk assessment in order to be able to identify those key indicators that those transactions, whether those transactions pose either a greater or a lower risk of money laundering.
And you can see some common threads there in terms of the regular risk assessment, the ongoing risk assessment, looking out for red flags. So it's interesting to see that although there might be slightly different regimes, there are a number of common threads as you might expect. Thank you both so much for your insights during this session. I've really enjoyed hearing from you both. And thank you too for listening. We are continuing with this practice across the pond series of pondcasts, as we're going to know them, and we'll be delighted if you could join us for the next one, which we're planning to talk about transatlantic structures. Thanks again. Bye-bye.